been referred to as the submittal due date over a period of time. As you know, water agencies have to undertake work to comply with this permit. They have to allocate staff resources. They have to budget for personnel, materials, and equipment that's required to comply with the permit. So that phase-in of the submittal due date gives water agencies a reasonable period of time to complete that work and prepare for implementation. There is one point on which additional clarification from the board and board staff would be helpful. Currently, the additional detail that was provided on TMDL implementation was very helpful in this latest draft of the permit, but we'd like the board to clearly identify their intent relative to the inclusion of TMDL specific permit requirements into this permit. We think that, consistent with the direction that was identified in the notice that was provided after the October workshop, and the general permit's goals of consistent and efficient regulation of these low threat discharges statewide, we do think that a statement basically saying that that this permit is a candidate for reopening or changes to incorporate TMDL specific requirements would be beneficial. I think attachment G, the TMDL attachment of the permit, says that new TMDL requirements can be implemented through this permit, but a statement that all TMDL permit requirements could be implemented through this permit would be helpful. So, with that, the only thing I have left to do is to really thank State Board staff, Diana, Renan, and that team for all of their effort related to this. State Board management as well as Marley and Phil and OCC for doing such a great job over this time. So
there's been a lot of time with folks, a lot of iterations of this one. Can you explain the TMDL piece again? Because I thought you have a piece on the TMDL inclusion. So what's the difference?
We do have a process there of what we're going to do with the data, but I think the expectation is that the requirements in the permit, meaning once we identify if there's an issue or not an issue, BMP should be sufficient enough to make this the permit to implement those requirements. And like I said, we still feel this is a low threat discharge, so we don't expect problems with the TMDL requirements.
But does it cover all current?
It covers all
TMDLs?
current.
That was my understanding.
Right.
As well as new. Is that correct?
It covers all current TMDLs, and if there's any new ones that get adopted in the future, those will be added to attachment G.
All right, so we would need to add it. That makes sense, because who knows what it's going to be. It might be an issue, so you want to have someone at least look at it, right?
Correct.
I think the issue that we're looking for clarity on this, and I think we're probably saying the same thing, we just want to be crystal clear on this point. Dischargers who are in a situation where they're looking at the requirements of an existing TMDL have to submit additional data under this permit. The question is what's done with that data after it's submitted. It's possible that an individual NPDES permit could be required. We just wanted clarity on the point that the state board has the authority to amend this permit to incorporate any requirements for existing TMDLs. If in the event that they become necessary. The permit does include clear findings saying that existing TMDLs are covered, but again, folks have to submit monitoring data proving that out over time, and presumably that'll be looked at. So we just want to tie up all the loose ends here.
Want to think about that?
I understand actually what Adam is saying, and if we want to get that fine-tuned, we can. Attachment G is a placeholder. As we looked at all the existing TMDLs, we do not see a case where the requirements under this proposed permit would not address those existing TMDLs. So the placeholder is for any new TMDLs that is very clear that these type of discharges need to be addressed with additional requirements, and then we would put the additional requirements in attachment G. If you do want to get more fine-tuned like that, I have no opposition, but we've already did this evaluation, and you do have the authority, if necessary, to open this permit up.
Right, we do.
So my question for clarification, is that, are you asking for a reopener that says that if it's determined that there's specific requirements that are needed based on the monitoring, that they would go into this permit as opposed to an individual permit?
Yes, and or specifically a statement to the effect that the board has the authority to reopen this permit as opposed, and it's more your intent than your authority, whether it's your intent to leave the option of reopening this permit open for to reopen this permit for existing TMDL requirements.
I will ask the lawyers to tell us if we have that authority. It is not our intent at this point to reopen this permit, but because of all of these people having to come here again.
Not that we don't love them.
Well, since Mr. Bishop has asked the question, I mean, the board would have the authority. It could be expressly included within the reopener paragraphs that are already enumerated in the order. And it would essentially, we'd still have to go through, as John indicated, a permit modification process, but it would express the intent that Mr. Valikevitz is asking for, that the board would at least be amenable to reopening the general permit to incorporate TMDL requirements as it seems appropriate.
If,
Okay. Why don't you all put that pin in that one for coming back
And-
at the end, and whether you want to do it or not?
Just a note, we do have on page 17 a reopener provision,
I
and that is in all our NPDS permits.
It's been made clear to me that the existing reopener authority sort of captures what I was trying to get at here, so that's helpful for me.
Is that?
Yeah.
Okay, good. That was worth
And actually, before you leave the podium, though, you made in your comments, you touch upon the issue of outreach and education, and I appreciate that. That is indeed very important, as I think we've learned throughout this entire process. Looking back at the sanitary sewer systems permit that this board adopted, one of the things that I think has made it so successful was the assistance that we received from the POTW community through TriTech, CASA, and I forgot all the acronyms, with respect to that education and outreach. And so I guess I'm going to put you on the spot and ask for Aqua's assistance and ask that you work with the staff to develop some kind of a partnership on that aspect with respect to this permit, should the board adopt this permit today.
And we also have in the room, and I think we'll be hearing later from Tim Worley from AWWA.
Right, we also have the California Water
And so there may be some
Association.
partners
If all of
for
the
this, yeah.
associations that cover agencies would host webinars for us,
Yes.
we'd be delighted.
So we stand ready to assist in any way that would be helpful for water agencies as they, work to come into compliance with this permit or enroll under this permit. I'll note that,
Or even don't
there-
be scared of this permit.
there's an-
I mean, that's half of our challenge is folks fearing that we mean something other than what we mean.
There's an example of
On all
actually a
sides.
recent success where Aqua worked with the NPDS program staff on letting folks know, putting together workshops, again, around the state that informed folks about the requirements and the opportunities under the aquatic weed permit. And we, traveled up and down the state, had a little roadshow where we basically gave folks an opportunity to learn more about that. So, I think that's a good model. Whether for this permit, webinars or workshops are more appropriate, it's certainly a conversation we look forward to having. So we do
Thank
look
you.
forward to continuing to work with you.
Appreciate that. Great, thanks.
Thank you.
Diana?
Good.
Yes, before Mr. W. walks away, I do
Mr.
want
W,
to...
that's the thing.
I
I was
can't
just
pronounce
thinking
his
Michael
last
is just
name.
showing off and making me look bad.
I
Wow.
do want to recognize his good intention on his comments, because what I'm understanding is we don't want to see regional boards go off and write additional individual permits if this one can somehow accommodate additional requirements for TMDL. So I just want to let you know that I do recognize your message here.
Thank you.
Good, thanks. Now we have a choice. This is an either-or, very neatly either-or, with title and email, et cetera. So is it going to be Francois Rodigari or Mary Lynn Coffey? Francois, excellent.
Also, if I might say something, the visitor center downstairs has a cell phone, so if somebody's missing a cell phone, it is downstairs.
So, good afternoon, Madam Chair, members of the board.
Noon, nice to see you.
My name is Francois Rodigari, and I work for San Jose Water Company. I'm here to speak on behalf of the California Water Association, which is an association that represents...
I'm sorry, get a little closer to the microphone as you speak so that it will work.
Thank
And
you.
you had asked ahead of time to do a presentation, so they get a little more time.
So, my name is Francois Rodigari. I'm here to speak on behalf of the California Water Association, which is an association of investor-owned utilities. There's 115 investor-owned utilities in the state of California, and at least represented by CWA. And I have some specific comments related to the current draft version that I wanted to make on behalf of CWA. Before that, I wanted to take an opportunity to thank the leadership of the State Board and staff for really what is a very good, workable permit. So I do want to make it clear that we are not in any way opposed to this permit or trying to delay it at this point. However, we were hoping to make a few comments and see if they could be taken into consideration. There is, and all of our comments, I should note, are not really related to the substance of the permit. They are more clarification issues and language issues which could cause some confusion down the road and potentially result in litigation, which we would like to avoid, particularly third-party plaintiffs type of litigation. There is some confusion regarding the authorized discharges. Actually, I think you resolved that one issue, so we'll skip over the first portion of that. There is some confusion, sorry about that. There's some confusion actually who is authorized to discharge under this permit, because the permit refers to drinking water systems or community water systems. And clearly, I think the intent is that they are similar, but we just think that the language should be consistent, so there is no question as to whether or not a discharger is actually authorized to discharge under the permit.
Is it, can you stop for a second? Is that, I missed that in the comments, et cetera. What, is that an issue you can clarify?
Yes, I think we'd like to clarify, but after Francois
Okay, so just take
explains
them
it,
all
if you
down.
don't mind.
Okay.
Sure.
Fine, fine.
Thank you. We believe that this can be simply fixed.
I'm sorry, it's a kind of a challenging,
Yes,
Fair.
apparently. It's
We don't
more
do that on
complicated than I
purpose.
can handle.
but
We would like to propose a solution to this issue by modifying the language on page 9 and 10, simply to strengthen what issuance of a notice of applicability means, and that essentially it would recognize that the discharger is eligible for and provided coverage under this permit, and that the discharges proposed are not likely to cause or contribute to violations of water quality standards. So that's just to address the issues that were previously discussed and to make sure that there is no ambiguity as to who is authorized to discharge under this permit. I'm definitely having some problems here. My apologies.
That's all right. No,
I don't know exactly where I am.
Go back to the beginning and then
yes.
go forward. That's usually better.
So the language related to the violation of the receiving water, I think, has been dealt with previously. And so, again, that resolution has taken place, so I thank you for that. So we'll skip over that. We do have some concern in terms of what information can be used, site-specific information can be used relative to show non-compliance. I believe the language was intended to recognize that at times it is not possible to monitor receiving water, and therefore site-specific information could be used to determine non-compliance. We do think the language is a little awkward, and we would like to allow the discharger to take into consideration all data that come from the monitoring plan or representative monitoring, and really that data to show compliance rather than non-compliance. So we don't necessarily want to have to prove non-compliance. We would like to be able to demonstrate that we were in compliance using the data available.
So were you saying in the, because we've left, as I understand it, we've left a provision that you could use the site-specific, if let's say you just dumped a boatload of chlorine into a water body, it's pretty clear there's going to be a problem, and it's the key thing that we're trying to avoid.
That is correct.
Here. But
So
you're saying you don't want us to be able to use that if that's there?
No. What we're saying is that certainly that information is relevant. However, if one can demonstrate that the chlorine traveled down a dry drainage, was naturally attenuated, or if there is representative data that shows what happens to those type of discharges, or if they are addressed in a monitoring plan. I think we want to be able to make sure that we can use that information to paint an accurate picture.
I don't think there's a limitation on that, is there?
No, I do understand what Francois is talking about, and this is on page, I believe it's page 8. I'm sorry, I'm going to flip to the permit really quickly. On page 18. So this is in regards to determining compliance with the receiving water limitations, which
right.
apply at the receiving water.
Right.
These are for indirect discharges, those that would go into a stormwater
Right.
system. This permit does not require those dischargers to conduct receiving water
Right.
monitoring.
Right.
So it was our intention to state that if there is a concern regarding compliance with receiving water limits, that additional information that is gathered on the site-specific receiving water may be used. And so we were thinking of it as additional because any other information they have on the discharge is already in the public record. They're either keeping it among their records or they have submitted it. I see what he's saying. He just wants to make it clear that all data is to be used and not just have the presumption.
Do you want to think about that?
I'm fine with his suggestion if you're open to adding it.
Okay, thank you. So the next one is related to the backwash exclusion, and actually after today's discussion, we're going to skip over that and withdraw the comment.
Okay.
So that'll make it a little easier. On the TMDLs, I believe that there is definitely some concern on what will happen when regional board adopt new TMDLs. And our concern is how will this permit be affected by it? How will the conditions be affected by it? And who will have to take the leadership on addressing and thinking about those issues? So clearly, we do not want the individual dischargers to have to work with their regional boards and then work with the state board to try to figure out how compliance will be.
Right, you want us to own it because we're doing this general permit
Yes.
we're making you enroll in.
That is correct.
That seems fair.
Okay. So again, we were hoping to have potentially some draft language revised so that it is clear that the State Water Board's Directive of Water Quality will propose all new TMDL-related permit requirements and effluent limitations for drinking water system discharges. So that's kind of in the same vein as Adam presented, just slightly differently stated.
We'll come back to it.
Okay.
I'm sorry, I started
No
jumping
worries.
in as opposed to going through
I
the start.
I have 4 minutes left. In terms of the biologist certification, the language currently requires a certified biologist or biologist to certify that the beneficial uses have been restored, which then kind of makes the presumption that there was impact on the beneficial uses from potable water discharges. We believe that's not necessarily the case, and so the language should be revised simply to state that the biologist could certify that the beneficial uses have not been impacted if that is appropriate, and I'll cover some language there as well. In addition to that, there is a requirement that that certification take place currently in the language that reads in a fashion that can be understood that current termination of a regional permit would trigger a biologist certification, which would happen when the NOA is actually issued by the state. So we would like the language to be changed so that it is clear that the intent that the certification was going to happen if the discharger ceases all discharges under this permit, or ceases operation, which I think that's what the intent was, or whether, or if all NPDES permits for those type of discharges are withdrawn. So this is some proposed language specifically to kind of change the current draft to make it a little more clear and not to assume that discharges have had a negative impact on the beneficial uses, and also to clarify as to when a biologist certification will be required. On the identification of waters of the U.S., I have comments that are similar to the ones made prior, although a slightly different angle. We appreciate the fact that the dischargers do not have to identify every water of the U.S. or to determine if a dry ditch is in fact a water of the U.S. So we can file an NOI, and for the purpose of the NOI, it is assumed that the discharger discharges water to waters of the U.S. However, we do not want that to be construed that is a formal delineation of water of the U.S. In other words, it is only assumed for permitting purposes. Again, to resolve that issue, then, we would propose the following language, which is to make clear that waters of the U.S. may be assumed without being formally delineated solely for purpose of seeking coverage under the statewide permit. And on the declaration of waste, which is my last point, we have difficulties with the current language in Section 6 that describes some of our discharges as waste. Clearly, water utilities, public water suppliers, discharge because they need to do it to protect public health. There is no reason to discharge water if that water can be served to the public. So it is done under circumstances when it's required to maintain water quality. We certainly support the fact that water should be beneficially reused if possible, and the permit language currently has language to that effect and incentivizes beneficial reuse, and we believe that's fair. The problem is in terms of categorizing a discharge as a waste, it's asking us to make a determination that really cannot be done by us and cannot really done under this permit. So we would just recommend that the first sentence of Section 6 just be deleted to remove the notion that our discharges are wasteful and could be avoided. That is critical because the implication of wasting water has implication on the rights of, to that water by the discharger. So it is possible that someone could make the argument that if we are found to waste water, we should lose our rights to that water. So that is the concern. And that concludes my presentation. I thank you very much. And I do have a summary sheet that gives out actual language for every one of those points. I don't know if I can submit it, if it would be helpful.
No, go ahead and submit it and give it to Ms. Messina in particular and
Okay.
the team.
Thank you very much.
All right. Do you want to come back to these later? Do you want to, and see what else other people say, or do you want to?
It may be helpful to just address them now, and it may be informative for other commenters.
Okay.
Mhm.
Okay.
So should we start?
Yeah, if you don't mind, go ahead. I know you like to
Okay,
keep track.
very good. Thank you, Francois. All right. So, and I believe I got them all. So the first comment is in regards to the notice of applicability, and that is the letter that will be issued to an applicant once they do receive coverage under this permit. We do have a section in the permit which describes the process for obtaining a notice of applicability. And the commenter is asking that we include language in the permit that says once you have received this notice, that your discharge is essentially a low-threat discharge. That would make the whole thing complete. I think the permit itself already has findings that discharges authorized under this permit are low threat. They do not adversely affect beneficial uses. So his request is something that is additional language, which we do not oppose if you want to accommodate it. But it's not necessarily saying anything new. It's just giving them a little more comfort. Okay. The second item is in regards to the compliance determination, which I think we already addressed. All data is used and is to be used when determining if there is a violation. We wanted to make sure we put language that additional outside data may also be used, since we're not requiring the discharger to conduct receiving water monitoring. So when we're looking at a potential receiving water limit violation, we wanted to make sure there was information in there that says we can use other data. Of course, the data they collect is public data, and they are keeping it on record for the State Water Board, and per our request, they must submit it. So that is public data.
But what I understood that to be, and maybe I'm just conflating it and you know it better, is that if we have that data that they're supposed to submit, and they want to give us other data about the fact that it dissipated, or here's where it went later, somewhere in between where it was and where the receiving water was, why couldn't they? They're afraid that that would be excluded.
Correct.
And I'm not sure we have all of that in the records.
We will have the compliance data that they gather for their effluent.
Right.
Right, and that is the data that they are asking that we also put in the permit, that we will consider that data as well. And so we're open to that, and we're agreeable to that if the board
Right.
directs us to include that.
But I thought he was saying even more data than that, than the basic compliance data, but also other circumstantial data or existing data about what happened after. I mean, generally, if we were getting into enforcement, they would obviously be able to bring that in. That's why I'm trying to understand if there's something that seems to limit their ability to give us mitigating circumstances.
I believe we may be saying the same thing, because the language in the permit says we may consider additional data.
Oh, okay, it does say that.
And if I'm not capturing the full comment correctly, I hope someone will note that. Okay. The next item is in regards to TMDLs, and the commenter was proposing that the deputy director is allowed to propose new language for when a new TMDL is developed, so that it will be implemented through this. We are open to that. However, I just want to clarify that when a TMDL goes through the public process, through the regional boards, that the state board does not necessarily step in during the public process.
Right.
And so the deputy director can do so after a new TMDL is developed. And typically we do that when we renew an NPDES permit. We don't like to reopen a permit midterm. But as we would renew a permit every 5 years, we would look at the newest TMDLs and how to apply them.
But he just wants to make sure that we will take the responsibility that when there is a new TMDL, we will, at an appropriate time, incorporate it into this permit.
Correct. And so we agree with that. So for example, when this permit is renewed in 5 years from now, we will look at all the new TMDLs that have been adopted and do the same thing we did with this one and incorporate them as necessary.
And in the interim, the TMDL wouldn't apply to this discharge because it's covered by this permit.
Well, the way that
That's correct. The TMDLs are not self-implementing, and so until
Right.
they're included in the permit, it doesn't apply to the people.
I think that's what he was looking for, so that clarification.
Okay.
Okay.
All right. The next item I have noted is on the biological certification. This is a requirement of the state implementation plan, and it's tied into the statewide exception that is being granted and implemented through this permit. I'm not sure about the comments. The way I read the slide, it's as if we would be requiring a biological certification sooner than later. What we have placed in the permit is that we would not be requiring that certification until that system stops discharging, which means that municipality is no longer using their system, no longer operating it in ways that has discharges to waters of the U.S. We can look further into what he's suggesting, but we want to make sure that we are not imposing a requirement that all these systems hire, or these municipalities hire a biologist upon just the change from a regional board permit to a state permit or vice versa, because that's a lot of cost that we want to avoid.
Yeah.
Right, and I think the impression that they have is that we are requiring certification more often
No, but
than
it's,
we intend.
but it's really, it's within permit coverage termination. There's a section of the permit that's very specific where a biologist gets involved. That is, we're not going to have any more discharges. We're terminating coverage under
Right,
this
it's not
permit.
every time we had a discharge and we had to review it.
This may not
Right.
ever happen.
Right. I think they're misinterpreting the section that
Yeah, I
we're
think
talking
you're right.
about, biologist certification. And it really is referring to just this NPDES permit or subsequent renewal of this permit. It's not really making a reference to another permit, but I think they're interpreting it as referring to another different permit. In addition, the certification language that we have here is exactly as what the state implementation policy requires us to include. So I don't know if we can modify that language.
Well, it's I don't think I think he was asking for clarification more than anything, and the language he was suggesting was to clarify.
But he's also making a comment that the beneficial uses not necessarily need to be restored, that they have not been impacted. I think he also had that kind of comment. But I think the assumption for the exception is that they're going to be allowed to discharge pollutants that may be in exceedance of criteria, therefore may be impacting beneficial uses.
Right,
And that's why the biologist certification would assure that that's not the case
right. And that biologist certification comes,
after completion of the project.
okay.
So, in other words, the concern would be, you know, project as it's described, it could be interpreted to mean, oh, this superchlorination activity we're going to do, you know, in June this year. But that's not the intent here at all. This is only gets triggered when you're filing a notice to be terminated under the coverage.
Right, the project is intended to cover the entire duration of the discharge while the system is in operation, the entire
Right.
system. So that's a very long
Yeah. So, yeah,
time frame.
I
Begs the
understand the
question
confusion.
whether we should have biologists look at it more often than you propose.
Well, there is something in here about unplanned discharge, right? If there are impacts, there's don't you have in the permit, the biologist looks when you know, if there's been impacts, the process of enforcement and certification that beneficial uses have been restored. Is that in here?
I don't believe for unplanned discharges we have
Okay.
such requirement.
Okay, because that's a tool we commonly use, you know, especially in sanitary sewer overflows. If there's some kind of impacts to the receiving waters, that's a common method regional boards use. So,
Okay,
Yeah.
hopefully
So,
that clarified.
I'd like to clarify this right now, please. The permit proposes that upon completion of the project, the discharger shall provide certification by a certified biologist that beneficial uses of the receiving water have been restored. For drinking water system discharges, completion of the project is when the water purveyor ceases discharge from its drinking water system under this order or subsequently reissued order, or when the state and/or regional water board terminates NPDES coverage for the discharges, whichever is sooner. And so it seems like there is a misconception that if a regional board terminates their permit and the folks come under our permit, that
have
they
get a
need to hire
biologist.
one. Right. So I will go in here and propose language to
Okay,
you.
great. And there were two more.
Okay. All right, there were two more. The fifth one is for the identification of waters of the United States and the presumption that all surface waters are waters of the United States. And Marley's going to address this.
Yes, as I understood the comment, there was concern that if they are conservative about looking at what could be a discharge to a water of the U.S. when doing their notice of intent to discharge, that would be binding on them later, that
Right.
if they are sued, that they would be precluded from
Right.
saying that it's not a water of the U.S. I don't believe that would be binding. I don't think obtaining NPDES permit coverage and being a little broader than you need to be precludes any later defense in a third-party lawsuit.
Might
then-
not, somebody, you might have to argue about it in court, because someone would say you already opted in. Is there, I mean, I'm not trying to limit it necessarily, but I think in the good intent to make it simpler for them so we wouldn't have maps, have to do all that mapping, so you're doing a broader presumption. I don't see anything wrong with saying what it's used for and clarifying it.
I agree.
It just would save some time later on. They might win ultimately, but why make them have to go through it?
So it would be to add some language to the notice of intent that the mapping is not binding for purposes of any later water of the U.S.
Right, if they're opting into the broader thing, it's not presuming anything.
Okay, we'll look at that.
I mean, it's such a fraught area. There are plenty of things to fight about. Why make people fight about more than they need to?
All right, and the last comment I have is on page 16, section 4. And that has to do with the word waste in the context of when we are discussing multiple uses and beneficial reuse. And that's in the first sentence that reads, "The discharge of surface waters may be considered wasteful when it is feasible for the water to be used prior to discharge." And so it's that word wasteful that is of concern to them. We did rewrite this. We acknowledge comments we got from an environmental group that wanted to make sure that the board was clear that any discharges to surface water that was not necessary be put to beneficial use or reuse. And so it's that word wasteful. I really have no opinion on it. This is a very sensitive issue, and I will leave that up to the board. But the word wasteful, I think, is a little different than waste.
Yeah, I'll look to Michael on that one, or Jonathan, if you want to answer the question. I think the intention is to incentivize beneficial reuse whenever you can, because water is scarce, not to, I mean, it would seem like a weird place to go on the wasteful use front, but.
I don't believe that a finding by a regional board or by us that someone could have reused water would be sufficient to lose their water right, which
I
seems to be
doubt that.
the issue. But
Well, I guess what I go back to is, as Ms. Messina read the first paragraph, it's that it may be considered, which is just an acknowledgement that in certain circumstances it will be. It's not a binding determination. And the board has expressed an intent about, in prior workshops on this, that there really should be a consideration by the discharges of first attempting to reuse it. And so I think
If
flagging the
possible,
issue
right.
with discretionary language, recognizing it is sensitive, but you're not determining it is in fact wasteful. So from a legal perspective, it's not binding and I wouldn't be concerned about it, but it's the
Okay.
board's pleasure. It's your consideration for adoption.
All right, that helps me. Can I ask one other question? I know we've spent a long time, but this is one
Sure.
of the main stakeholder groups this permit has an impact on. There was an early slide that he had about confusion over whether we were calling, whether it was drinking water systems or community water systems. Can you say if that makes a difference? 'Cause I know there is a difference, but I don't know that it would make a difference, although I suspect many, well, at least small water systems are exempted. But what was your reaction to that confusion?
Our reaction is this. We do have the definition of a community water system, which is a system of 15 connections or more.
Right.
We do have the link that a drinking water system that's to be regulated under this permit is a community water system. then when we raise the threshold for required enrollment under this permit from 15 to 1,000, it seems like there's a difference in definitions. We do have a footnote, though, immediately after, and so basically, this permit regulates discharges from drinking water systems of 15 connections or more. This board is requiring these drinking water systems, or as you want to say, these community water systems that have 1,000
Right.
connections or more to enroll under this permit.
Right.
So it could be confusing, but we wanted to make sure we allowed for that increase in the threshold, which we discussed at an earlier workshop. Okay.
But why call it two different things?
We
What am
in-
I missing?
Okay, we included the definition of a community drinking water system the same as our Division of Drinking Water does. And that is because we've determined in this permit that we are allowing any system that has 15 connections or more to take NPDES coverage
Yeah, they
under
can
this
opt in
permit.
if they want
They
to.
can opt in. So this permit will cover all community drinking water systems. It's just your requirement for who must enroll, which has
Got it.
that different number.
And that's clarified in the footnote, is what you're saying?
Yes.
Okay. Good. Let's move on, and then we'll come
Very good.
come back. Thank you for keeping track there. Catherine Rubin, LADWP.
Good afternoon. I'm Catherine Rubin from the Los Angeles Department of Water and Power.
Get a little closer to it. Just pull it closer to you.
Yeah. Now?
Thanks.
Okay. And LADWP appreciates your staff on all the different revisions they made. We believe that they've put together a workable permit, and we particularly want to say thank you to Diana and Raynon for working with LADWP, and they showed the changes that they made for us up on the permit. So we're very appreciative of the dialogue and that we could come up with solutions for us. We also had a question, though, about the qualified biologist. We were a little confused with that as well. And we thought maybe we suggest that possibly, because we thought it was just for termination of the permit, that you could just cross out the wording subsequently reissued order and then put the period after the last sentence for the dischargers and take out whichever is sooner. I don't know if that is what is that what you did, Diana? Okay, well, see, we
Talk
think
about
alike now.
responsiveness. I mean, it's impressive, isn't it?
Right,
Yeah.
see? We've spent a lot of time together, so.
Yeah. Good.
All right, thank you.
Oh, good, thanks. All right, Ricky Russell, California Coastkeeper Alliance.
Good afternoon, Board, Madam Chair. Ricky Russell with California Coastkeeper Alliance. To reiterate from previous oral comments, I would like to express our organization's satisfaction with the inclusion of language and actions that will encourage beneficial reuse of the discharged drinking water. We feel like that is a strong steps in the permit, and we're appreciative of those inclusions. I would further like to express our thanks in the inclusion of the changes to the turbidity requirements for the well discharges for rehabilitation, and we believe that that is an important inclusion, as our organization feels strongly that monitoring requirements must implement practices and standards that accurately assess measures to and measure real-time conditions of discharges. Speaking to that, we are a bit concerned about what we feel are rollbacks to the emergency discharge monitoring requirements. We are sensitive to the concerns of agencies about the difficulties of monitoring under certain circumstances. To that end, we'd like to maybe suggest that there be maybe minimum requirements or some kind of look at when a threshold of emergency discharges. I know that would be difficult, but something that kind of looks for when emergency discharges occur to monitor exactly what happens. But all in all, we would like to thank the board for working to develop a permit that benefits ecosystems, permittees, and board resources. For this reason, we still strongly believe that the board should adopt a permit that covers as many water systems as possible, as it is a good permit, and we feel that everyone who can be covered under the permit should be encouraged. So with that said, on behalf of California Coastkeeper Alliance, thank you for your time and consideration.
Thank you very much, and thank you for your help through the process. Illuminated some really important issues.
Yeah, I mean, we don't have to cover it now, but I am interested in, the emergency monitoring regime description, because we didn't go over that in the staff report.
Okay.
Yeah, go ahead.
Just want to make sure it's clarified that emergency discharges and the NPDES permitting usually can be exempted from having to do any monitoring and comply with requirements. So we just want to make it clear now that with regards to receiving water, we're not expecting them to do any monitoring, because emergency discharges, again, are exempt. I believe under environmental requirements, they are exempt, and Marley can add to that, but it is my understanding that emergency discharges can be exempt in NPDES permitting.
And how are emergency discharges defined?
The definition, let me,
That's
I
a
was
good-
only half listening. I was looking at,
Oh, yeah.
the question was the emergency discharges being exempted from CEQA, is that correct?
No, just
No,
the
it has to
definition.
do with the
NPDES
definition
permitting.
and
Okay.
reporting.
Maybe we're distinguishing, or do we distinguish emergency versus unplanned?
We used them to mean the same thing to a certain degree in the mitigated negative declaration for the resolution, but there are unplanned discharges that, Diana, help me out here, that may or may not be emergency, but emergency discharges, I think as it's used in the permit, has a more specific
Pipe
meaning.
break, someone hits a fire hydrant.
So there is actually a definition in the definition section, which says a discharge due to a sudden, uninspected occurrence involving a clear and immediate danger, demanding immediate action to prevent mitigation of loss or damage or life, health, property, or essential public services. So this is not a unplanned discharge.
everyday.
This is
Good. No, I think we've handled that appropriately. But there is the unplanned side, which has a lot of implications for management.
Right. I'm sorry, I asked Renan if he would answer this, and now I'm stepping in. There is a difference between emergency and unplanned. And this goes back to talking to a lot of the water districts on what actually goes on out there in the field when this stuff happens. There's discharges that are emergencies, just like Mr. Bishop just read the definition we have. Then there's unplanned discharges that they occur but they're not scheduled. They weren't planned to occur, but they take place. They may not be as severe as causing loss of property and so forth. When we met with Ms. Rubin, we understood even more what goes on in a situation when there is an emergency, such as they have on a daily basis, and we were surprised how many quote-unquote unplanned and emergency discharges they have on a daily
You
basis.
have not worked in a city
And,
agency.
right, it is not the intention of
Does
this
that mean
permit to
miles of
keep the
pipe?
dischargers overly busy to collect information for us. We're trying to find the right spot to hit.
Right.
And so we have backed off a little bit because there's a lot of pressing issues that an agency must take or must address when these emergencies happen. We did back off somewhat, but we're comfortable with where we've backed off to, unless, as this permit goes forward, we do see that there's issues that do need to be addressed and we have to make another step forward on that.
Yeah, I think we had a conversation. If you find a place that, a community that's having a zillion unplanned discharges, then you have to step in and reconsider it. So this is one of those understandable provisions you've put in unless it gets abused.
Yeah, and especially if there's impacts, you know, the outcome part of this.
Right,
If there's
that's right, right,
sedimentation,
right,
if there's
exactly.
chlorine in receiving waters, all those
Correct.
type of
Yeah.
things.
And keep in mind, we're looking to capture 80% of the discharges statewide approximately, and those other 20% may need additional requirements.
Okay. Good, thanks, that's helpful. All right, Tim Worley, California Nevada Section, American Water Works Association. Hello.
I had the luxury of changing my greeting from good morning to good afternoon, so
Thank you very much.
thank you, Chair Marcus and members of the board, for allowing us to make some comments. These comments are, by this time in the process, really quite general. California Nevada section of the American Water Works Association has a long history of promoting sound science and sensible regulation to protect water sources from pollution and to protect public health through safe drinking water. Our 4,700 members in the California community of water professionals work every day to make a reality of the state's declaration that safe, affordable, accessible drinking water is a basic human right. We love the goals of the Clean Water Act, and we love the goals of the Safe Drinking Water Act. Our members obviously would prefer to have sources that are unpolluted to those that are polluted. At the same time, in order to convey, treat, and distribute drinking water under the Safe Drinking Water Act, it is necessary at times to discharge to waters of the United States. This water may be untreated, or it may be treated. The discharge may be planned, unplanned, or emergency, as we just discussed.
Mhm.
It may be infrequent, or in some cases, it may be relatively frequent. Sometimes these discharges may have environmental impacts, many times they don't. Where there are negative impacts, our members support the need to minimize and to mitigate those. In any case, our members are unanimous in their preference not to be subject to onerous permitting costs and requirements, astronomical fines, or third-party lawsuits under one law just for doing what is necessary to comply with another law. So with that context, we really appreciate the board's objective to adopt a general permit that brings some order and consistency to the regulatory environment, even though some of our members were happy with the status quo.
Right.
We also greatly appreciate the water board staff, the staff who have been mentioned before, for their outstanding efforts to hear, understand, and accommodate our views and concerns. Some of the issues have been as challenging for us as they have been for your staff because of the wide disparity or diversity of specific water sources and operations. We strongly support a general permit that covers all discharges related to potable water, specifically one that covers all discharges from surface water treatment plants and groundwater treatment facilities. The November 7th draft permit excludes specific operations related to surface water treatment plants and groundwater treatment facilities, yet these discharges are necessary to meet requirements of the Safe Drinking Water Act. Excluding some operations and processes related to surface water treatment plants and groundwater treatment facilities can lead to numerous inefficiencies throughout the state, which is contrary actually to the state board's strategic goal to, quote, enhance consistency across the water boards on an